Welcome to the I Got Fired podcast. I'm Tom Spiegel, founder of the Spiegel Law Firm, where we help people who have been fired or are afraid that they might be. And today we're going to be talking about mediation. We're going to do a series on mediation in the litigation process. We're going to talk today about the foundations and the essential aspects that all mediation share. Then we're going to have 3 separate episodes after this that vary depending on the specialized type of mediation. For instance, there's mediation before an administrative body or often the EEOC. Excuse me. There's mediation with the court, and there's also private mediation. So we're going to have a separate episode on all of those. But let's start today with what mediation is. So mediation is a process by which parties come together to try to resolve or settle a lawsuit before trial, or in the case of an administrative proceeding, before the case proceeds into the investigative phase. Mediation is different from arbitration. It's another word you may hear come up in talking to your lawyer when considering these things. Arbitration is more of a trial-like proceeding. So we'll have a separate podcast on that, but today we're going to talk about mediation. So what is the foundation of mediation? What's it going to look like? No matter what the forum is, mediation tends to follow along these tracks. First of all, it is, regardless of where it occurs, it's always private. This is not a public forum, unlike a trial, or the court, which is a public forum. Mediation is a private opportunity for the parties to sit down and try to resolve a lawsuit or a dispute. It is confidential. What is said in mediation cannot be used as evidence later at trial. So nothing that comes out of mediation can be used in the litigation process. What happens in mediation stays in mediation. The other aspect of mediation, which is common across all types, is the format in which it occurs. Whether it's before a judge or before a private mediator or before somebody at the EEOC or another administrative body, it's going to work like this. Prior to the mediation, parties are going to sign documents, generally, where everybody agrees that what is said is confidential, that nothing is going to be used at trial. And then once you get to the mediation, what will generally happen is there's a conference room that everybody meets in. So it will be you. It'll be somebody from your employer. If you have a lawyer, your lawyer will be there. If the company has a lawyer, the company lawyer will be there. And then there will be the mediator. And the mediator will come in and usually go through some kind of preliminary discussion about how the process is going to work. And they're going to walk through the fact that it is confidential. They're going to walk through, how it's going to work, which is generally both sides, setting forth their position, and then the mediator going back and forth trying to resolve the dispute. So that's generally how it happens. You walk into a conference room, it's going to be you and whoever's with you. It's going to be the other party and whoever's with the other party and the mediator. And the mediator will usually just be by him or herself. There's no court reporter because, again, this is not a place where evidence is generated. There's going to be no need for a transcript. You couldn't use it later even if you wanted to. So it's usually just going to be the mediator. And then the mediator will give each side an opportunity to essentially make kind of an opening statement. So remember, everybody's at the room, you're at the table together, and this is your chance to talk to the other side and the other side's chance to talk to you. Now, in a minute, we'll talk about, because it's possible to waive that and choose not to make a statement, and we'll talk about the strategy behind that. But regardless of whether an opening statement is made or not, what will happen next is that one of the groups of people, either you or the employer and their people, will move to another room, right? So everybody's in a different room, and the mediator will essentially come to, they'll start in one room, and they'll come to, say it's you, and they come to you and they say, okay, here's, what is it that you want? What is it that you're asking for? Now, depending on the type of mediation or where this has happened, the mediator may know a lot about your case, and there may have been documents exchanged beforehand particularly if it's private mediation, about where parties stand and what your, settlement range is. But whether that's, happened to this point or not, that's one thing that the mediator will discuss with you. And so the mediator will say, what you want, what are your kind of touch points, what's your settlement range, and he or she may give you some analysis of what they, think the strength of your case is. Sometimes that won't happen until later in the process, but it's possible that the mediator may at that point, give you some indication of what they think about your case. So, but anyway, let's say, the mediator comes to you and they say, well, I understand that your starting position, let's say in your case, it's $100,000. That you want to settle for $100,000, are there anything, if they write you a check for $100,000, is that going to resolve this case? And maybe there are other things that you want. For example, you want a non-compete waived, or you want a mutual non-disparagement. And this is important. Why it's important for you to, and if you've watched our legal leverage videos and gone through this process, and you'll have an idea of what this means, to know what your number is. Like, where are you really willing to walk out of that room, with? Because if you come in wishy-washy, or this is the first time you've given it serious thought, then you're going to be at a tactical disadvantage. So you want to share with the mediator, this is what I want out of this case. I want, $100,000. Remember, this is going to be the starting point, right? You're not going to get, your first ask. I want my non-compete waived. I want a mutual non-disparagement, whatever these things are. I will note that a lot of mediators, they really get focused on the money, which of course is important. That tends to be one of the biggest sticking points, but you do not want to lose sight of the fact that there are other things that may be important to you in the settlement, and to walk in there understanding that, because one difficulty that happens in all kinds of mediations is everybody finally agrees on a number, and then at the end, your employer, your former employer, through their attorney or whoever they have, sends you a document that asks you to sign, and it has all this stuff in it, right? What you can and can't do, what you can and can't say, and you read it and you're like, well, I'm not willing to sign this. And then it just throws, a big a wrench in the works, because you've essentially blown up the settlement. And I'm not saying you shouldn't do that, but understand that the mediator may not be focused on that. So if it's important, again, if you've gone through our legal leverage videos, our process, you understand this, but it's important that you have talked to your attorney, if you have an attorney, or that you've thought about those things that are non-negotiable for you. And of course, there may be things you are willing to give on. Maybe you don't care about, a non-disclosure provision. Maybe non-compete's not an issue. Maybe a reference is not something you really care about. And so these are things that are on the table for you, but you're willing to give. So you need to have some idea of what that universe is, and you want to give yourself some wiggle room, right? You don't want to come in and say, it's $100,000 or I'm walking, because you're not going to get $100,000. So then the mediator will go back to the other room, and it'll be shuttle diplomacy. The mediator will go back to the other room and say, the other side has told me this. Where are you guys? And let's say it's your employer, and the employer is like, well, we're willing to settle the case for $25,000. And the non-compete is, negotiable for us, and we're fine with a mutual non-disparagement. Often it'll just, again, the mediator may not be having that conversation with them. Often it's just about the money. That's why it's important that you keep these non-monetary factors in mind, when you're considering about what you want to walk out of there, because if the mediation is successful, often at the end, there will be a general settlement agreement. It may not have everything in it, because you're not going to be able to get it all spelled out in one session. Parties may leave the room with a general understanding, and then there will be followed up with what the fine details are. Again, that's another area to make really clear what you're willing to sign in that contract, because what can also happen is, hey, this goes on for a long time, everybody's tired, they've agreed on a number, kind of the broad outlines of a settlement agreement, and then the employer often will be the one who drafts it, or does the first draft, and they've got all the stuff in it that you're not willing to sign. So you want to keep that in mind when you're going in. What's your number? What are your non-monetaries? And then so what'll happen is the mediator is going to go back and forth between the two rooms, and this process can take an hour if both sides are intractable and it doesn't look like there's going to be any meeting in the middle. Why are we wasting everybody's time, particularly if the mediator's not very good? It could take, I've had mediations that have gone on well into, they start at say 10 o'clock in the morning, they go well into the night because there's back and forth. Parties are starting to move. They're starting to make some concessions and move towards some middle ground. And so the mediator's going to keep going. A couple of things to keep in mind. The mediator will almost, it's like a conversation with a friend. They're going to keep most of what you say confidential. So if you say to the mediator, hey, look, the money's something I can work on, but I really, this non-compete, getting it waived is something that's really important to me, so when you're going back to the other side, make sure you communicate to them. Or, depending on how comfortable you are with the mediator, you might even show a little bit more of what your strategy is and say, look, we're willing to work on the money, but I want you to come in at, $100,000. And we're of course willing to come down off of that, and we'll figure out how much. One thing to keep in mind just as a tactical matter is, the mediator, most of them of course are operating in good faith, but they want to get this case settled, and they're going to go and share things with the other side. And so I guess my point is you want to keep a little bit in the tank, right? You don't want to say to the mediator like everything that you're willing to do, because you want the mediator engaged. And so you want the mediator to come back to you and say, well, they've offered $50,000. They're willing to not waive the non-compete, and they want, a non-disparagement agreement. They don't want it to be mutual. They want it to be one-sided. You're basically just agreeing not to talk. And you want to be able to, say, well, that's really tough. We wanted 100,000. Look, we're willing to come down to 80. And in your mind, you may be thinking, again, why it's important to know your numbers. I'm willing to come down to 60. If this will get this done and I can get these other non-monetary factors resolved, I'm willing to come down to 60. But you don't tell them that right up front. Again, if you've got an attorney, you'll be working with your attorney on this. So you want to keep a little bit in the take. It's a little bit of a performance. So, so how long can it take? Again, if both sides are intractable, you've got an inexperienced mediator, it could be over in an hour or a couple hours. If it's going well and you're making progress, it can go a long time. So that's, make sure you bring your refreshments with you. If you need cigarettes, if you need a coffee drink, if you need a power bar, whatever it is, to get you through the day, make sure you bring those supplies with you, because depending on how hot and heavy things get, you may not be able to step outside to as much as you might want to go get lunch. There may not be a break for food depending on how this is going. And in some cases they will bring food in. So it's not that you're going to starve, but it's better to be prepared. If hey, but at 3 o'clock, if I don't get my boost of caffeine, I'm going to be useless. Well, I'd bring it with you. Just so you're prepared. So it can go, like I said, it can go for a while. And again, sometimes if it goes south, it can, be less than a couple of hours. So going back to the opening statement, you could choose to give an opening statement. I mean, this is your chance to talk to the other side, and it may be the only time, the first time that if there's an attorney on the other side that they've heard your side of the story from you. It can either come from you personally or it can come from your lawyer. And remember, there's no transcript there. There's nobody taking notes. You're not held to anything. You can say within reason whatever you want. And sometimes it can be helpful for the other side to hear from you directly, particularly if there's a lot of emotion. Because one thing that the other side's going to be doing, particularly if there's an attorney on the other side, they're thinking, let's assume that there hasn't been a deposition yet. They don't know they've never met you before in person. They're looking at you and thinking, what kind of witness is this person going to be? And if you're very effective at telling your story, and there's some emotion behind it, I mean, the proper amount of emotion, I'm talking about screaming, yelling, but if you break down and cry, the opposing counsel is going to look at that and think, okay, I don't want a jury seeing this. So that can be very effective. And the other side's going to be able to make their statement too, right? So if if you're the employee, you're coming out, you're making your statement. The other side may also elect to make a statement. And Here's the thing, and the danger behind making an opening statement, and why you might want to consider waiving the right to say it. And you just have to make your own judgment about how you think you would perform and talk with your attorney. At a mediation, you are trying to get the other side to do something voluntarily, right? You're trying to get them to sign a check, to sign a document, to make some concessions to you. So you want to give them an incentive to move towards your position. And if you come out, guns blazing, making accusations, even if true, making all these, accusations, and let's say the wrongdoer, the person, let's say, harassed you, is in the room, and he or she may or may not be. If you come out guns blazing against that person, well, they might get angry, right? And then all of a sudden, your chances of making any meaningful progress on this settlement dim because you've made the statement. So it's a judgment call. There's no right or wrong answer. And remember this, the other side's going to make their statement too. And they may say all kinds of things about you that make you angry. And then all of a sudden, like you walked in there thinking, okay, I'd settle this for $80,000 and a waiver of my non-compete. And now you're thinking, forget that. Like, there's no amount of money I'm willing to settle this case for, because they said all these things about me. So just be prepared for that. If you're going to make a statement, if the other side is going to make a statement, because they're also, remember, the mediator's not making a decision. They have no authority over your case at this point. They're not making a ruling. But that said, each side is trying to influence the mediator, right? The mediator's human, and he or she's making, has thoughts in his or her own mind about, who's in the right here or how this should go. And so the parties are sort of playing to that person as well when they make that statement. So judgment call as to whether you make it. I often, except in unusual circumstances, advise my clients to waive that opening statement, just because the perils of getting everybody upset are really high. That said, if my client feels really strongly about making the statement, if I think they'll speak well for themselves, if I think, perhaps I have a relationship with opposing counsel and I can speak to them and they're opposing their party in a way that I think, would be persuasive to them, I might do it. So again, a judgment call, but realize that it's not required. And you can have one side make a statement. Like, you may like to give a statement, and the defense may be like, we're not going to make a statement. So, and that's okay too. So, to reiterate, come in there knowing, kind of in at least broad strokes, what you're willing to settle for. Come in there with your supplies. Understand that it may take hours to get this done. Be strategic about your interactions with your mediator. You want to be honest with them and give them the tools that they need to move the other side. But you don't want to lay your cards out on the table, I think, right out front, because you want to give yourself some wiggle room as the process goes on. And understand that it may not be successful. I've had mediations go again for hours and hours and hours, and we get right to the finish line and something happens and somebody's like, nope, we're not doing it. Or, I've been in mediations where the judge will come back and say, the other side is saying they're done. They don't want to proceed any further. And that happens. So you got to be prepared for that. So, and if at the end of the mediation, it doesn't work, well, what happens? You go back as if it never happened, right? Remember, this is all that was said in mediation stays in mediation. This is all confidential. There's no record of it. You go back to the litigation as if you never had the mediation, and that's not necessarily a failure, because mediation, you can also learn things from the other side, right? You get to, again, you're not going to be able to use this as evidence, but you're going to hear a lot about what the other side thinks and about what their theory of the case is. So you're going to walk out of there wiser whether you settle it or not. So, big fan of mediation. There's a high likelihood in your case, if it proceeds any distance, particularly past the EOC, that you're going to have mediation. Most cases, a lot of cases resolve there. So in some ways, you're not so much initially preparing for trial as you are for mediation. And if it goes south, you will have gotten some useful intelligence about the other side, and you can go on about the litigation. So that is the general outline of how mediation occurs. Again, it almost doesn't matter where. That is the process and kind of the strategy, the overall strategy behind mediation. So I hope you found that helpful. Good luck if you've got mediation coming up. Like I said, our next episodes, we'll be talking about mediation before specific bodies. Our next one will be mediation before the Equal Employment Opportunity Commission or another administrative agency. Then we'll do one on mediation before a court or a magistrate. And then the final one will be private mediation. All right, take care and good luck.